Hi, today's topic is going to be on virtual company meetings during the COVID-19 pandemic. My name is Nicholas Navran, and if you have any queries, you can submit the queries at the chat box provided or to my email address, and I will deal with it at the end of this session. So again, for those who have arrived, have just come into the session, today's topic is on virtual company meetings during the COVID-19 pandemic. So the COVID-19 pandemic has actually forced companies to explore alternative measures in order to keep their businesses afloat. And one of these includes the virtual company meetings. And according to the census done by the Securities Commission, about approximately 246 fully virtual company meetings have been convened since March 2020 until July 2020. So there's a bit of an increase in respect of the fully virtual company meetings. But for the purpose of today's talk, we're going to deal with shareholders meetings instead of board meetings. For board meetings, the capability of board to convene meetings is generally dependent on the constitution of the company, and each company does not really adopt the same constitution. So if you want to determine whether or not the constitution or the company allows virtual board meetings to be convened, then the main question that you need to ask is whether or not the constitution explicitly or exclusively requires physical meeting to be convened. If the answer is in the affirmative, then the board meeting cannot be convened by way of virtual meetings. What if the constitution is silent on the mode for the meeting to be convened? If that's the case, then if the constitution is silent on that manner, then the board can freely convene virtual meeting. So for today's topic, we're going to the outline for it are the following. Firstly, we're going to deal with what are virtual meetings. Second, what are the pros and cons of virtual meetings. Third, where do companies derive their authority to convene virtual meetings? We have dealt with it briefly just now, but only in respect of board meetings. What are the requirements? And lastly, what are the requirements to convene virtual meetings? Okay. So what are the modes for meetings? So generally you have the physical meetings, which are meetings attended physically by the shareholders at a physical venue. So this is the conventional way of convening a meeting, which has always been adopted and preferred by the shareholders, especially in companies in Malaysia. The second one would be the fully virtual meetings, which forms the topic of today's talk. Fully virtual meetings are meetings attended by the shareholders remotely, without their physical presence at any physical venue. So does that mean that no physical venue is required? Does that mean that the company does not have to prepare or arrange for a physical venue to be fixed? Actually, no. So there is one physical venue that the company has to arrange, which is the broadcast venue. It's pretty self-explanatory. It's the place where the virtual meeting is broadcasted from. Okay, so that broadcast venue is attended by the chairperson of the meeting. It has to be attended by the chairperson of the meeting, as well as other essential persons, which I will deal with shortly. So virtual meetings do not mean that the meetings have to be visual. They can be done merely by way of teleconferencing facilities. So you call that person. If you have a meeting by way of a telephone call, then it's sufficient enough, provided that all the requirements are complied with. And lastly is the hybrid meeting. The hybrid meeting is a combination of physical meetings and physical meetings and virtual meetings. So the shareholders have the option of attending the meetings either remotely or physically. Okay. The Securities Commission for public listed companies, the Securities Commission has issued guidance and frequently asked questions on the conduct of general meetings for listed issuers. So for public listed companies, you can refer to this guidance note. Two of the points provided in this guidance is that firstly, public listed companies located in the areas under the CMCO can only conduct fully virtual meeting. But public listed companies cannot use an area under the targeted enhanced movement control order or the enhanced movement control order as its broadcast venue. Okay, so what are the circumstances if you have the option to convene a virtual meeting or a physical meeting? What are the circumstances that you need to take into account? So that's where the advantages and the disadvantages of virtual meetings may come into play. So the first advantage of having a virtual meeting is the level of participation that you can garner from it. So the Securities Commission has actually conducted a survey, and according to the survey, there was an increased level of participation online because, and according to them, and I'm reading from their report, from the SC's engagement with several, despite the relatively smaller number of meeting participants, 31% of listed companies responded that shareholders posed more questions during the fully virtual AGMs compared to the physical AGMs. And the Securities Commission went on further to state that one of the likely reasons is the ease of posing questions using the chat box in a fully virtual meeting compared to a physical meeting where shareholders will have to wait for their turn to pose questions. So that's the first advantage of having a virtual meeting. The second one would be the reduction of costs. A reduction of costs would mean that if you convene a virtual meeting, you can dispense with the need for paperwork. Travel expenses can be reduced as well. And access to recording of the meetings, some of the technologies, for example, Zoom has the option or facility to record the meeting, and members can refer to the recording of the meetings immediately, subject of course to the administrative guidelines issued by the companies. And lastly, the favorable environmental effect, which would concern, amongst others, reduction of carbon footprint of the attendees. So the disadvantages of virtual meetings, as I mentioned earlier, that one of the advantages is the participation of the members, but it doesn't necessarily guarantee the attendance of the members. And this was actually highlighted by the Securities Commission. Though the virtual meeting increases the ability of members to join the company meetings, it does not necessarily guarantee, because some shareholders are still apprehensive about joining virtual meetings. They are not really they do not favor virtual meetings, and according to them, according to their report, and I'm reading from it, the largest difference recorded from one of the meeting from 1,300 to 25 meeting participants at a physical general meeting. Only 108 attended the fully virtual general meeting. That was a significant reduction of the attendance in the numbers of participants. And according to their discussion with the several stakeholders, Securities Commission also mentioned that one of the likely reasons for the decrease in participation was due to the absence of door gifts, meals or refreshments, which are common features of AGMs in Malaysia. Okay. Second is the technical and communication errors, and one of this is the unstable internet connection. Not everyone has access to stable internet connection. Another reason is the chat box used during the virtual meetings, because some of the chat box features are on the real-time basis. some of the questions posed by the shareholders, the other shareholders might have missed the questions. This is by comparison to the physical meetings, the shareholders present during the meetings will be able to know what the questions are which are posed by the other shareholders. So it is harder in that sense for the shareholders to track the questions that have been posed by the shareholders and the information which they need to know in order to come to a resolution. Okay. Thirdly, the facilities required, the software and the hardware required. Some may not have the facilities required. And lastly, the psychological factors, which would mean that some of the complex issues are better left dealt with in physical meetings. Okay. So the enabling statutory provision is Section 327 of the Companies Act 2016. Subparagraph 1 reads, subject to the Constitution, a company may convene a meeting of members at more than one venue using any technology or method that enables the members of the company to participate and to exercise the members' rights to speak and vote at the meeting. Subparagraph 2, the main venue of the meeting shall be in Malaysia. The chairperson shall be present at that main venue of the meeting. So from this provision, we know that there are two sources, possible sources from which a company derives its authority to convene fully virtual, partial hybrid meetings. And one of them is the constitution of the company itself, the constitution of the company being the Articles of Association. If the constitution is silent on the mode for which the meeting is to be convened, then Section 327 applies. Okay. Some of the requirements have already been set out here in Section 327, namely that the technology or method employed must enable the members of the company to participate and to exercise the members' rights to speak and vote. And this would relate to the second main requirement for the meeting, which is that the meeting has to be effective. Secondly is that the main venue shall be in Malaysia. The main venue is in reference to the broadcast venue. It is not in relation to any physical meeting to be attended by the shareholders. And lastly, the chairperson must be present at the broadcast venue. Okay. So the usual procedure for convening meetings still applies. So you have the quorum, the issuance of notice. The notice has to be issued within the timeline prescribed by the Act or Constitution to be followed. The contents must be sufficient. Place, time, date, and general nature of business. So the place would be in reference to the broadcast venue of the virtual meeting. Okay. So now we can look into the guidance note. The guidance note provides that the physical attendance of essential persons as follows. So firstly, the chairperson, second, CEO, CFO, company secretary, scrutineer, auditor, and those providing audio visual support. So for chairperson, their attendance is required. They have to be present at the broadcast venue. As for the rest of the essential persons, their presence is optional, depending on whether or not their absence could still render the meeting effective. Okay, so there are additional requirements under the guidance note. Firstly is the company must ensure that there is reliable infrastructure. Reliable infrastructure to enable the conduct of a fully virtual meeting, particularly that which enables the members to exercise the right to speak and vote at a meeting. There must be guidance on the guidance to the shareholders on the requirements and method of participation. This includes procedures for registration and online remote participation. The broadcast venue must be identified, and eligible members are the only ones who are allowed to participate in the meeting. The applicable directive, safety and precautionary requirements prescribed by the relevant authorities such as the government, the Ministry of Health, are to be observed, and dedicated contact number and email to for the shareholders to submit queries or requests for technical assistance must be provided to the shareholders. So for the purpose of the notice, some of the information can be provided in the administrative guide or the administrative note to be appended to the notice. Some of these are the guidance on the requirements and method of participation, and the dedicated contact number or email to submit queries or requests for technical assistance. And this has been adopted by some of the companies here. I believe LPI Capital Berhad and Eco World Development Group Berhad, they have provided this information in their notice of meeting. And now we move on to the portion where the meeting has to be effective. So the virtual meetings have to be effective in the sense that the technology or manner employed to conduct the virtual meetings enables the members of the company to participate and to exercise their rights to speak and vote at the meeting. This is in reference to Section 327, Sub 1 of the Companies Act 2016. This is also in consonance with Section 71, Sub 1 of the Companies Act, which provides that members have the right to participate, to attend, and speak at a meeting. So what happens if the meeting is not effective? In the sense that the members were not capable of speaking or voting or debating at a meeting. So now, for that portion, I believe any resolution passed at a meeting is susceptible to challenge. And one of the case that we can refer to is the case of the English Court of Appeal case of Bing and London Life Association. Now, in that case, a number of the members could not and did not know how to carry out their registration formalities. Bear in mind that this is not a virtual meeting case, but nevertheless, the principles are still applicable. So the number of the members could not and did not know how to carry out the registration formalities. The meeting rooms could not sufficiently accommodate the members. There was no audio-visual link between the meeting rooms, and accordingly, the members could not exchange their views. So the English Court of Appeal held that the purpose of members attending meetings is to enable them not only to vote, but also to take part in the debate. I would therefore allow the appeal and declare that proceedings purportedly conducted at the meeting at the Café Royal in the afternoon are invalid and of no effect. And there are, of course, there are certain questions which are irrelevant. The chairperson is, of course, entitled to ignore it if they are truly irrelevant to the business of the company at that time. Yeah. Okay, any question? Okay, I believe there are no questions from from those present. If you have any questions, you can submit your queries to my email address, and I will attend to the queries. Okay, thank you.